Please be seated. Good morning. The sitting is now open. The court meets this morning to hear the oral statements of Uruguay, Somalia, Switzerland, Vanuatu, the International Cooperative Alliance, and Business Africa. I recall that each of the delegations has 30 minutes at its disposal for its presentation. The court will observe a short break after Switzerland. I shall now give the floor to His Excellency Ambassador Álvaro González Otero, speaking on behalf of Uruguay. Sir, you have the floor.
Mr. President, distinguished members of the court, it is an honor to appear before you today on behalf of the Oriental Republic of Uruguay as ambassador to the Kingdom of the Netherlands. This is the second time that Uruguay appears before this court in an advisory opinion procedure, a fact that underlines the importance we attach to the advisory function of this tribunal. My country has closely followed the development of these proceedings from their inception, fully aware of the importance of the legal issues raised for the international community and for the interpretation of one of the core instruments of the International Labour Organization. In light of the far-reaching implications that its advisory procedure may have for the international legal order and for the credibility of the multilateral system, Uruguay considered it essential to join the deliberations of this court at this final stage, so as to share its long-standing experience and commitment to the protection of labor rights, freedom of association, and the central role of the International Labour Organization within the United Nations system. I have the honor of introducing the delegation representing Uruguay. With me is Ambassador Alejandra de Vélez, permanent representative of Uruguay to the United Nations and specialized agencies in Geneva. And we are also accompanied by Ms. Rosina Álvarez, an assistant from the embassy. Thank you.
Otero for his presentation. I now call upon Her Excellency Ambassador Alejandra de Vélez to take the floor. Madam, you have the floor.
Mr. President, distinguished members of the court has consistently affirmed that it enjoys discretion in deciding whether to render an advisory opinion, even when jurisdictional requirements are met. This discretion, however, must be exercised only in the presence of compelling reasons not to respond. Uruguay respectfully submits that no compelling reasons exist that would justify the court declining to exercise its jurisdiction in the present case. First, the request was submitted by the International Labour Organization, a specialized agency of the United Nations, empowered to seek advisory opinions pursuant to Article 96(2) of the Charter and Article 65 of the Statute of the Court. There is no doubt as the competence of the requesting body or the admissibility of the question. Second, the question posed is legal in nature. It concerns the interpretation of a multilateral treaty, Convention number 87, ratified by 155 ILO members. The court's jurisprudence from the Western Sahara Advisory Opinion, 1975, to the Chagos Archipelago Opinion 2019 confirms that politically sensitive questions can still be of legal nature and admissible. Third, the institutional autonomy of the ILO is not compromised by this request. Rather, the ILO's own government body has by majority, chosen to refer this matter to the court. Fourth, the suggestion that the issue is better resolved through ILO internal mechanisms, Article 37(2) of the ILO Constitution, ignores the deadlock that has characterized those mechanisms in recent years. Diverging views between workers and employers groups on the scope of Convention 87 have reached an impasse. The court is thus uniquely positioned to provide clarity. Fifth, the court's advisory function exists precisely to assist UN organs and specialized agencies when legal clarity is needed. Rendering an opinion in this case would advance the object and purpose of the ILO Constitution, particularly Articles 1 and 19, which emphasize legal certainty and coherence in international labor standards. Finally, Uruguay is convinced that a favorable opinion by this court would not only reaffirm the authority of the International Labour Organization, but also bring to an end the long-standing debate that have divided its supervisory system for decades. Such an authoritative pronouncement would dispel uncertainty, close this chapter of controversy, and provide the clarity required for the effective and coherent functioning of the multilateral system. On the interpretation of the ILO Convention 87, Mr. President, members of the court, Uruguay considers it appropriate to center its submission around three key dimensions of the issue before the court. First, the effect that a reaffirmation of the ILO's long-standing position may have for the future of the multilateral system. Second, the extent to which such a clarification will ensure the fulfillment of the basic objectives of the International Labour Organization. And third, the protection of the fundamental right to freedom of association, of which the right to strike is an essential expression. The government of the Oriental Republic of Uruguay fully shares the view that social dialogue and the search for tripartite consensus are absolutely essential in the field of labor relations at all levels. However, Uruguay recalls that such a mechanism has already taken place in the international sphere since 2012. Despite the good faith and commitment of all constituents, it was not possible to reach an agreement, thereby leaving open the avenue of Article 37(1) of the ILO Constitution. Uruguay shares and supports the legal interpretation that the right to strike is protected under Convention 87 as an essential component of the right to freedom of association, and stands here to further develop this interpretation and its arguments. This interpretation has been consistently affirmed by the ILO supervisory bodies, in particular the Committee on Freedom of Association and the Committee of Experts of the Application of Conventions and Recommendations. While their opinions are not legally binding in a judicial sense, Uruguay considers their interpretative guidance to carry considerable legal and institutional weight, especially given the long-standing and consistent nature of their position over several decades. The right to strike, in our view, is not merely an ancillary element, but rather an intrinsic expression of the rights recognized in Article 3, 8, and 10 of Convention 87, which guarantee the autonomy of workers' organizations to organize their activities and formulate their programs, and the right to organize actions to promote and defend the worker interests. In particular, Article 3.1 affirms that workers' organizations shall have the right to organize their activities and to formulate their programs, and Article 8.1 provides that in exercising the right provided for in the Convention, workers' organizations shall respect the national law. The ILO supervisory bodies have long interpreted this to include strike action as a legitimate means to defend occupational interests. Uruguay submits that the correct approach to the interpretation of Convention 87 must be teleological, in line with Article 31.1 of the Vienna Convention of the Law of Treaties. That provision requires that treaties be interpreted in good faith in accordance with the ordinary meaning of their terms, in their context, and in the light of their object and purpose. Applied to Convention 87, the principle of good faith entails that the freedom of association cannot be understood in a purely formal or minimalist sense. To interpret this freedom in a way that would exclude the right to strike would deprive workers' organizations of their most essential tool to defend and promote their interests. Such a restrictive reading would not reflect good faith interpretation, but rather a mechanical literalism that empties the treaty of its practical meaning. Good faith requires that the Convention be read in a way that makes its protections effective in the real world of labor relations. Moreover, good faith interpretation cannot be separate from the object and purpose of Convention 87, which is to ensure the genuine and effective exercise of freedom of association for workers and employers. The travaux préparatoires confirm that the drafter intended to enshrine a broad and flexible protection, leaving space for the natural development of trade union freedoms, including strike action. Thus, Uruguay respectfully submits that the principle of good faith, as codified in Article 31 of the Vienna Convention, requires this court to recognize the right to strike as both a right in itself and a corollary that gives real force to the freedom of association protected under Convention 87. Only such an interpretation ensures the effectiveness of the treaty and maintains the coherence of the international legal system. The object and purpose of Convention 87 is to secure the effective enjoyment of freedom of association for workers and employers alike. Within this framework, the right to strike emerged not as an extraneous addition, but as an inherent element of freedom of association. It is the natural corollary of the autonomy of workers' organizations to formulate their programs and organize their activities. Uruguay wishes to emphasize the systemic and indivisible nature of freedom of association under Convention 87. There exists a natural and almost automatic dynamic between organization, collective bargaining, and strike action to the point that any attempt to artificially separate this element distorts their very essence. Trade unions organizations, collective negotiation of working conditions, and the right to strike are inseparable expressions of freedom of association. The absence of any of these components undermines the others. Together, they form an integrated whole. In this sense, the right to freedom of association is not exhausted by the possibility of creating and affiliating to unions, drafting statutes, or administering organizations. Above all, it implies the right to exercise trade union activity in its broadest sense, as enshrined in Article 3 of the Convention 87. While it's not possible to determine exhaustively all activities that fall within this scope, it is difficult to conceive that the right to strike, the most singular and distinctive instrument available to workers, would not be included. The strike, as a right that allows the suspension of the employment contract without sanction by the employer, requires a robust legal recognition. Such recognition can only be achieved by acknowledging its intrinsic link to freedom of association. For that reason, the omission of the word strike in the text of the Convention 87 does not exclude it, but rather confirms that the general notion of trade union activity is sufficiently broad to encompass it. Moreover, under Article 31(3)(b) of the Vienna Convention of the Law of Treaties, subsequent practice in the application of a treaty which established the agreement of the parties regarding its interpretation must be taken into account. The consistent practice of states, as well as the interpretative guidance of ILO supervisory bodies over more than six decades, confirm that the right to strike is firmly understood as part of the freedom of association protected by Convention 87. With regard to the importance of the matter at the level of fundamental rights, Uruguay wishes to emphasize that the dual character of the right to strike is its connections with freedom of association. First, it is a right in itself, as the full exercise and natural corollary of freedom of association. No other foundation could sustain it. Second, it is a right that guarantees the effectiveness of other rights, for it opens as the essential source of effectiveness of freedom of association. Without the possibility of strike action, the right to organize would remain largely theoretical, lacking the force necessary to protect the interests of workers in practice. The long and fruitful work of the International Labour Organization in development of international labor standards would be incomplete if those norms lacked effective mechanisms for their realization. As in any field of law, rights requires instruments to make them operational. In labor relations, such instruments may be heteronomous through laws, decrees, or regulations, but they may also be autonomous, arising from the initiative of workers themselves. The strike, exercised through their representative organizations, is the foremost autonomous mechanism for ensuring compliance with labor rights. This powerful legal instrument, recognized by international labor law, finds its justification in the structural inequality that characterizes the employment relationship. The worker, by definition, must submit to the authority and direction of the employer within a regime of legal subordination. In such a context, strike action is the indispensable counterweight that enables workers collectively to defend their interests and to ensure respect of their rights. As some of the most distinguished contemporary labor law jurists have pointed out, it is only through the right to freedom of association and the equalizing opportunity it provides that the subordination of one person to another in the employment relationship can be considered acceptable within a framework of justice and human dignity. Uruguay's own constitutional legal framework reflects a unique feature. While the right to strike is explicitly recognized in Article 57 of our Constitution, its exercise remains subject to only minimal statutory regulations. This deliberate choice has left a wide normative space in which international standards, and in particular ILO Convention 87, serve as the fundamental point of reference of both the organization and activities of trade unions and for the legitimacy of strike action. Its exercise continues to be subject to regulation by law or collective agreement. In this regard, Convention 87 has operated as the primary legal axis shaping the conduct of labor relations in Uruguay. Our judiciary and social partners consistently rely upon it to assess the scope and permissible limits of collective action. This practice illustrates how the Convention functions not only as an international obligation, but also as a domestic normative compass for trade union freedoms, including criteria for determining the maintenance of essential services during the strike. The Inter-American Human Rights Framework, to which Uruguay is a party, also reinforces this perspective. The Protocol of San Salvador, Article 8, protects trade union rights. Furthermore, Uruguay also recalls Advisory Opinion number 27, delivered by the Inter-American Court of Human Rights in 2021 at the request of the Inter-American Commission of Human Rights, who asked the court to clarify the scope of states' obligation under the American Convention on Human Rights in relation to freedom of association, the right to collective bargaining, and the right to strike, and to explain their interrelationship with other rights such as freedom of expression, freedom of assembly, and the right to work and to just, equitable, and satisfactory working conditions with a gender perspective. In its response, the Inter-American Court affirmed that the right to strike is not an accessory, but an essential component of freedom of association, inseparable from the autonomy of workers' organizations to pursue their objectives. It further emphasized that any restrictions must be strictly limited, meeting requirements of legality, necessity, proportionality, and legitimacy in a democratic society. The authoritative pronouncement demonstrates that strike action operates both as a right itself and as a necessary corollary that gives real and practical effects to the freedom of association. Finally, the right to strike, while universally recognized as a cornerstone of labor law, has never been the subject of a separate international treaty, nor any codification project at the global level. This absence does not reflect a normative vacuum, but rather the widespread understanding that the right to strike is necessarily encompassed with the guarantees of freedom of association enshrined in Convention 87, and thus confirms our reasoning. Therefore, and in the light of all the foregoing, Uruguay respectfully submits that the right to strike is not an external addition to Convention 87, but a core element of the freedom of association it enshrines. A contrary interpretation would render the protections under the Convention incomplete and ineffective and would weaken a pillar of the international labor legal system. In conclusion, Mr. President, members of the Court, Uruguay respectfully submits that the right to strike is inseparable from the right to freedom of association. It is at once a right in itself and an essential guarantee that gives genuine strength and effectiveness to trade union freedoms. The right to organize unions, to bargain collectively, and to declare strikes are not isolated entitlements, but complementary expressions of a single legal source, freedom of association, as recognized in Article 3 of the ILO Convention 87. The object and purpose of that convention, in light of Article 31(1) of the Vienna Convention of the Law of Treaty, can only be fulfilled in the right to strike is understood as inherent within it. A pronouncement by this court that reaffirms the long-standing interpretation of the ILO supervisory system would bring clarity to decades of debate, ensuring legal certainty and reinforcing the credibility of the multilateral system of labor standards. It would also recognize the subsequent practice of states, including Uruguay, that has consistently treated strike actions as part of the freedom of association protected by the Convention 87. Mr. President, members of the court, Uruguay therefore invites this court to confirm that the right to strike is not external to Convention number 87, but forms part of its very essence, given practical meaning and effectiveness to the fundamental right to freedom of association. It is our understanding that at the end of first quarter of the 21st century, these human rights should be fully recognized and enforced in line also with SDG 8 on sustainable economic growth, full and productive employment, and decent work for all. This concludes Uruguay's oral submission before this court. We thank you for your attention. Thank you.
I thank the representatives of Uruguay for their presentation. I now invite the next participating delegation, Somalia, to take the floor. And I call Her Excellency Ambassador Hadija Osable Ali to the podium.
Bismillah ar-Rahman ar-Rahim. Mr. President, honorable members of the court, good morning. It's an honor to appear before you on behalf of the Federal Republic of Somalia. Somalia welcomes the governing body of the ILO's decision to request this advisory opinion on whether the right to strike is protected under Convention 87 on freedom of association and protection of the right to organize. The question before the court is both simple and fundamental. It's simple because it asks in binary terms whether Convention number 87 protects the right to strike. It's fundamental because the answer will determine the stability and credibility of the ILO supervisory system, a system that has guided states for decades in applying international labor standards. On the merit, Somalia's position is very clear. The right to strike is a fundamental element of freedom of association and is protected under Convention number 87. At the time of Somalia's ratification of the convention, Somali legislators acted on the belief that the right to strike was an integral and indispensable part of freedom of association. The preparatory work for the adoption of the convention did not reveal a contrary view, which further confirms the right to strike is firmly anchored in the spirit and the purpose of this instrument. Without it, freedom of association is hollow. Workers' organizations will be free to exist in letter, but denied the meaningful tool required to defend their members' interests. Unfortunately, upholding the right to strike also preserves the authority of the ILO supervisory system. For decades, its supervisory bodies have affirmed that Convention number 87 protects this right. To deny it now will not only unsettle the expectations of states, workers, and employers who have relied on that consistent practice, but also erode the credibility of the ILO's unique supervisory architect. The international recognition of the right to strike is mirrored in Somalia's own constitutional framework. Article 24 of our constitution explicitly guarantees every worker the right to strike. This aligns Somalia with the long-standing position of ILO supervisory bodies. Since ratifying Convention number 87 in 2014, Somalia has worked with ILO to align domestic law with international standards. Earlier this year, Somalia adopted a new labor code, the first major modernization of Somalia's labor legislation in more than 5 decades. In undertaking this reform, Somalia took guidance from the ILO to ensure that the new labor code conforms with international labor conventions and recommendations. Indeed, in accordance with Convention number 87, this law expressly safeguards the right to strike and provides for its effective enforcement in practice. By harmonizing our international obligation with domestic law, Somalia has ensured that the right to strike is protected through clear and enforceable legal provisions. Importantly, the right to strike in Somalia is not confined in paper guarantees. It's fully recognized, respected, and exercised in practice. Somali workers are empowered to use this right lawfully in defense of their economy and social interests. This demonstrates Somalia's strong commitment to giving life to both its international obligation and its constitutional promises. Somalia's experience has taught us that durable peace and sustainable development depend on effective labor institutions. Freedom of associations, including the right to strike, is indispensable to balancing the interests of workers and employers, preventing a dispute from escalating and fostering fair and stable industrial relations. Somalia, therefore, respectfully requests the court to confirm in its advisory opinion that the Convention number 87 protects the right to strike as an integral component of freedom of association. This concludes my remarks. I thank the court for its kind attention and request, Mr. President, that you please invite Mr. Guled Yusuf to address the court. Thank you very much.
I thank Her Excellency Ambassador Osabde Ali for her presentation. I now call upon Mr. Guled Yusuf to take the floor.
Mr. President, honorable members of the court, it's a privilege to appear before you for a variety of reasons. On behalf of the Federal Republic of Somalia in these proceedings, the preamble to the Constitution of the ILO sets out the aims of the organization. Formed after the First World War to advance social justice, the ILO's core objective, stated in the second paragraph, is the improvement of labor conditions whose neglect had produced such unrest that the peace and harmony of the world were imperiled. Put simply, the ILO exists to set standards that promote workers' rights and thereby advance social justice. Since 1919, the ILO has recognized that the improvement of labor conditions requires the effective recognition of freedom of association. To that end, in 1948, it adopted Convention number 87 on freedom of association and protection of the right to organize, one of the organization's 8 fundamental conventions, which its supervisory bodies have consistently read as protecting the right to strike. In this context, I'll address the court on 3 matters. First, that the starting point should be the conclusive interpretations of the Committee of Experts. Second, that as a matter of treaty interpretation, the right to strike is protected under the convention, and third, a brief reply to the arguments advanced by a minority who dispute the existence of such a right. Before turning to the substance of the question, two preliminary points on the court's role in these advisory proceedings must be addressed. I do not propose to address the court on matters of jurisdiction. There is overwhelming consensus that the court does have jurisdiction to give the advisory opinion requested. However, in my first preliminary submission, I wish to address a further issue that has arisen as a result of events leading to this request. On 24 October 2023, the International Organization of Employers told the ILO Director General that an advisory opinion would not resolve the dispute over the right to strike because there exists uncertainty regarding a binding effect of ICJ advisory opinions for the ILO and its constituents. The International Organization of Employers did not maintain that position in their written submissions to seek to dissuade the court from exercising its discretion. Even so, Somalia submits that the court should address the matter, not least because in the Committee of the Whole at the 349th session of the governing body, the employers group stated that they would not accept any advisory opinion of the ICJ, irrespective of its content. As a general matter, advisory opinions are of course non-binding and do not constitute decisions within the meaning of Article 94(1) of the United Nations Charter and Article 59 of the statute of this court. The court said as much early on in interpretation of peace treaties. Yet in interpretation of peace treaties, the court also drew a distinction between the advisory nature of the court's task and the particular effects that parties to an existing dispute may wish to attribute in their mutual relations to an advisory opinion of the court. Here, Article 37(1) of the ILO Constitution provides that any question or dispute relating to the interpretation of this Constitution or of any subsequent convention concluded by the members in pursuance of the provisions of this Constitution shall be referred for decision to the International Court of Justice. In other words, the organization thereby gives the court's answer a final and determinative effect, whatever the view of the employer's organization may be. This is not dissimilar to other international treaties that provide similar effect to this court's advisory opinions, including, for instance, Article 30 of the Convention on Privileges and Immunities of the UN. The ILO has itself noted that for more than a century, all tripart constituents, employers included, have accepted the binding legal effect of advisory opinions given at the ILO's request. If it were correct that despite the express reference to a decision in Article 37(1), the opinions of this court were not binding, then the provision's role as a dispute settlement mechanism would be meaningless and without effect. The court has not previously ruled on whether an advisory opinion can be treated as a decision. Given the employer's position, Somalia submits that it's necessary for the court to specify this time that when an organization's constitutional instrument expressly refers a question to the court for a decision, the organization itself accepts in advance that the court's advisory opinion will be determinative within its institutional framework. My second preliminary submission concerns the scope of the answer that the court may properly give to the question posed to it. Apart from legal submissions, the International Organization of Employers has sought to draw the court's attention to certain wider implications. The purpose of these observations was never articulated in their written submissions and remains untethered to any principle of law. Nevertheless, it bears noting that the International Organization of Employers has posited that if the court decided that Convention number 87 protected the right to strike, the majority, if not all, state parties to Convention number 87 would be found in violation of the Convention under the Committee of Experts' guidance of the right to strike. That submission is plainly without merit. The role of the court in these proceedings is to answer a narrow and specific question. By answering that question in the affirmative, the court would not be recognizing the right to strike as an absolute right, for it is not. Any right recognized by the court would exist only within the terms of the Convention and remain subject to the limitation in Article 8(1), which requires all rights under the Convention to be exercised in conformity with the law of the land. Thus, any limitations on such a right remain a matter of municipal law. What such limitations may be requires an analysis of national law, an issue not before this court. Turning then to the substance of the question before this court. The question before the court is narrow and binary, whether the convention recognizes the existence of a right to strike. The court has not been asked to define the scope or modalities of its exercise under national law. It is not concerned with the permissible limits, conditions, or implementation of that right. In short, these proceedings concern its existence, not its extent or regulation. Somalia, with the vast majority of participants, submits that the right to strike is a fundamental corollary of freedom of association and therefore protected under Article 3 of the Convention. By way of background, it's important to reiterate that although the question has come before this court for a final determination, the issue itself is not novel. Since 1959, the Committee of Experts on the Application of Conventions and Recommendations has noted that a prohibition on the right to strike may run counter to the Convention. In the General Survey of 2012, the committee squarely addressed the question before this court and concluded, by reference to the Vienna Convention on the Law of Treaties, that the absence of a concrete provision on the right to strike is not dispositive, and the right to strike derives from Convention number 87. It's well established that for over 70 years, the Committee of Experts has treated the right to strike as a corollary of freedom of association and therefore is recognized and protected by Convention number 87. The question for the court is what weight should properly be given to those long-standing and consistent views. Somalia does not suggest that the committee exercises a judicial function. The committee itself acknowledges that its opinions and recommendations are non-binding, being intended to guide the actions of national authorities. As noted earlier, only this court can give an authoritative interpretation. Still, that does not render the committee's work irrelevant. The court's jurisprudence demonstrates that the views of specialized, independent bodies provide a valid and persuasive starting point for resolving questions before it. The committee comprises 20 independent high-level jurists, judges, professors, and other legal experts that are appointed by the ILO's governing body. Its role is to provide an impartial technical analysis of how labor conventions are applied by member states. Its mandate, endorsed by all tripartite constituents, is clear. It must determine the legal scope, content, and meaning of the provisions of the conventions, that is, to interpret them. The court has given great weight to the interpretive practice of such specialist bodies. That principle was established in Diallo and reaffirmed in the application of CERD. Explaining the rationale of this approach, the court stated that the point here is to achieve the necessary clarity and the essential consistency of international law as well as legal security, to which both individuals with guaranteed rights and the states obliged to comply with treaty obligations are entitled. That logic applies in the present case. Of course, the court is not required to follow the committee's interpretations. However, as members of this court have observed in individual opinions, experts serving on such bodies may be considered to fall into the category of the most highly qualified publicists in this field. Accordingly, their views fall within Article 38(1)(d) of the statute and must inform the court's consideration of the questions before it. This approach is also reflected in the practice of regional courts. The European Court of Human Rights, for example, has taken account of the position of the ILO supervisory mechanism on the right to strike as an element of international law for the purpose of defining the meaning of terms and notions in the text of the convention. On that basis, the European Court of Human Rights had no hesitation in determining that a right to strike indisputably exists under the convention. In short, when a specialized expert body within a treaty structure consistently interprets the instrument it supervises, such interpretations form persuasive evidence of the treaty's ordinary meaning. The court should depart from the committee's longstanding view only for compelling reasons. None exist, in our view. The committee's interpretation aligns fully with the convention's meaning under customary rules of treaty interpretation. There is broad agreement that the question before the court is one of treaty interpretation under the customary rules reflected in Articles 31 and 32 of the Vienna Convention on the Law of Treaties. The question must therefore be answered by applying those well-established general rules of interpretation. For decades, Article 31 has been applied holistically. The ILC commentaries describe interpretation as a single combined operation in which wording, context, and object and purpose thrown into a crucible. This holistic approach is particularly apt in the case of treaties such as Convention number 87, which protect human rights, such as the right to freedom of association. The study group of the International Law Commission on the fragmentation of international law observed that in respect of human rights treaties, interpretation tends to seek their effet utile in a context perhaps wider than for regular treaties. This is consistent with the court's own practice in the interpretation of human rights and humanitarian instruments. In the Namibia advisory opinion, the court recognized the need to account for the evolutionary nature of broad concepts, such as sacred trust, and to interpret them in light of present conditions and purposes. Similarly, in the Wall advisory opinion, when interpreting the ICCPR, the court considered the broader object and purpose of human rights law in occupied territories. Those principles apply with equal force here. In interpreting the right to freedom of association, the court must ensure that it is effectively protected beyond a strict textual or originalist reading. The starting point of this approach remains, however, the ordinary meaning of the terms of the treaty, informed by their context, with the entire text being given effect by reference to its object and purpose. In that respect, Article 3.1 must be read together with Articles 2 and 10. The plain language of Article 3.1 provides for the protection of the workers' freedom to organize their activities. The ordinary meaning of activities is broad. The only limit appears in Articles 8 and 9. Article 8 provides that in exercising rights provided by the Convention, those concerned shall respect the law of the land, but such law shall not be such as to impair the guarantees provided in the Convention. Article 9 prescribes that national law determines the extent to which the guarantees provided by the Convention apply to the armed forces and police. Thus, Article 3 grants a right to organize activities without qualification. It is accepted by participants in these proceedings that the term activities of workers' organizations is of broad import and includes the right to strike. Nothing in the text limits it to administrative or organizational acts. In the ordinary English and French usage, it encompasses collective industrial action. This reading is reinforced by Article 10, which defines an organization under the Convention as one for furthering and defending the interests of workers. A workers' organization, as contemplated in Article 10, would lose all meaning or its effet utile if the right to strike were not protected. Read together, Articles 2, 3, and 10 form a coherent sequence. The right to form organizations in Article 2, to conduct their activities in Article 3, and to defend workers' interests in Article 10. Each provision builds on the next. None can operate effectively without the possibility of collective action, including the right to strike. This interpretation is further supported by the Convention's object and purpose. As I explained at the outset, the ILO Constitution seeks to improve labor conditions by recognizing freedom of association. The freedom of association is not, as the minority participants in these proceedings contend, an isolated and self-contained right detached from the realities of industrial relations. Freedom of association in labor relations is inherently functional. It exists to secure collective leverage, not abstract membership. The fact that the right to strike is an inherent component of such a freedom has been confirmed by expert bodies charged with the interpretation of multilateral human rights treaties, such as the ICCPR, as well as regional bodies, including the European Court of Human Rights and the Inter-American Court. Once the freedom of association is properly understood, it follows that the right to strike is within the object and purpose of the Convention. The title, Freedom of Association, and the protection of the right to organize, and the preamble's reaffirmation of that freedom to improve labor conditions confirm that the Convention protects activities aimed at that improvement, including strikes where necessary. This inherent link between the right to strike and the freedom of association as protected by the Convention is confirmed by two further elements. First, the subsequent practice of states, which the court must take into account pursuant to Article 31(3)(b) of the Vienna Convention. Second, the applicable rules of international law, such as universal and regional human rights instruments, which the court can take into account pursuant to Article 31(3)(c) of the Vienna Convention. These elements have been canvassed in detail in the written submissions before this court, and other states will have addressed them this week. So you'll be happy to hear, no doubt, I do not propose to rehearse them here. It suffices to say that taken together, the text, structure, object, purpose, and consistent practice leave no interpretive gap, and all point to a single conclusion. Convention number 87 recognizes and protects the right to strike as an integral part of the freedom of association. I turn briefly to the minority's objections. They make 2 points. First, the text of the convention does not specifically mention a right to strike, which they argue excludes it. Second, as the convention applies equally to workers and employers, the recognition of the right to strike would be inconsistent with the provisions of the convention, as such a right can only be exercised by workers and their organizations, not employers. In my respectful submission, neither argument withstands scrutiny. As to the absence of express language protecting the right to strike, this court and its predecessor have consistently recognized that silence in a treaty does not imply exclusion. Moreover, where it is accepted that convention sets out unqualified and broad protections, it would lead to absurdity if only particular enumerated rights were protected. A convention drafted to guarantee freedom cannot be read as forbidding everything it does not spell out. For instance, ICCPR's Article 19 guarantees the freedom of expression, and it is universally accepted that this protection includes press freedom, even though press freedom is not expressly mentioned. Similarly, the court, in its recent advisory opinion on obligations of states in respect of climate change, concluded that the right to a clean, healthy, and sustainable environment is inherent in the enjoyment of other human rights, including the right to life, proving that fundamental rights derive from purpose, not mere phrasing. As to the argument that Convention number 87 applies equally to workers and employers, that is a red herring. There is no dispute that the Convention also protects the rights of employers and their organizations. However, those rights are not the issue before the court in these proceedings. To the extent it is argued that Article 3 provides identical rights to both employers and workers, that too is incorrect. The plain language shows that Article 2 applies without distinction, but Article 3 protects the distinct rights of two classes, workers' organizations and employers' organizations, respectively. This is made clear by the repeated use of the word "their" in Article 3.1. In sum, none of the counter-arguments withstand a disciplined treaty interpretation. They mistake silence for exclusion and symmetry for identity. The text, structure, and purpose of the Convention all point in one direction. The right to strike exists and always has. Every argument to the contrary asks this court to rewrite, not interpret, the Convention. Mr. President, members of the court, to conclude, the court's advisory opinion presents an opportunity to continue the protection accorded to the foundational principle of the ILO, freedom of association. The right to strike is not an abstraction. It is a practical means by which workers pursue better conditions on equal footing. Its consistent affirmation over the decades has empowered workers to advance their rights before domestic courts and has provided states with stability in the frameworks they adopt to advance international labor standards. By affirming that the right to strike is protected under Convention number 87, the court will reinforce the global consensus on the necessity of collective bargaining as a tool for advancing social justice. Mr. President, honorable members of the court, this concludes Somalia's submissions. I thank you very much for your attention.
I thank the representatives of Somalia for their presentation. J'invite à présent la délégation de la Suisse à la barre.
I give the floor to the delegation of Switzerland, His Ambassador, His Excellency Ambassador Franz Perez. Mr. President, members of the court, it is an honor to appear before you on behalf of the Swiss Confederation, together with my colleague. The question of the protection of the right to strike under Convention number 87 has been debated for more than 30 years within the International Labour Organization. It is a fundamental issue that concerns all of the ILO's tripartite constituents. Since 1989, Some constituents have contested the interpretation that the right to strike is protected by Convention number 87. The controversy has gradually intensified, culminating in a major institutional crisis in 2012. For the first time, the ILO's supervisory system found itself unable to carry out its work and function. Faced with this deadlock, Switzerland initiated a mediation process between international social partners in 2013, which focused on the interpretation of ILO standards and the organization's entire supervisory system. More than a decade has passed since then. By participating in the present proceedings, Switzerland wishes once again to contribute to enabling the ILO and its constituents to overcome the problem that gave rise to the request for an advisory opinion from your court. Faithful to its attachment to tripartism and social dialogue, Switzerland sincerely hopes that a lasting solution will be found to preserve a calm, constructive, and legally secure working climate within the ILO's multilateral tripartite system. In its intervention, my delegation will first address the meaning and scope of the question put to the court before analyzing the interpretation of Convention number 87, particularly with regard to its object and purpose, as well as the subsequent practice. We will then consider the question of jurisdiction to define the arrangements for exercising the right to strike. Mr. President, members of the court, Switzerland, like all the parties to these proceedings, considers that the court has jurisdiction to give an advisory opinion in response to the request of the ILO governing body. Nevertheless, I would like to briefly comment on the content of the question submitted to the court and the way in which it should be interpreted. A too narrow interpretation of the question, namely simply whether the right to strike of workers and their organizations is protected by Convention 87, would not provide the ILO or its constituents with the necessary legal certainty. More specifically, in the event that your court were to consider that the right to strike is protected by Convention number 87, it would be appropriate for your court to provide information making it possible to determine the powers to define the terms and conditions of the right to strike. The question of jurisdiction and modalities of application is one of the points of law genuinely at issue in the present proceedings. It is clear from the presentations and observations that all the parties to the proceedings recognize the existence of a right to strike, whether or not it is protected by Convention number 87, while admitting that it cannot be absolute. Numerous contributions detail how this right is exercised, by whom and in what circumstances. Mr. President, members of the court, the question of protection of the right to strike, and in particular by Convention number 87, has always been linked to other institutional elements of the ILO supervisory system. Thus, for example, the deadlock that arose in 2012 and to which I referred in my introduction certainly arose around the issue of the right to strike and Convention number 87, but it also concerned the functioning of the ILO supervisory bodies. The discussions and declarations following this deadlock concerned not only Convention number 87 and the right to strike, but also the modalities of this right, the mandate of the Committee of Experts on the application of conventions and recommendations, the Committee of Experts, and the need to improve the procedures for monitoring and examining standards. These points should be borne in mind. They will enable you to appreciate the scope of the question posed. In order to respond to the legitimate concerns of all constituents, it would be appropriate for your court to address, in the first instance, the question of the existence of protection for the right to strike in Convention number 87 on freedom of association and protection of the right to organize. If it were to answer that question in the affirmative, it would then be necessary to define whether it falls within the competence of national legislators, the tripartite legislators of the International Labour Conference, or the ILO supervisory bodies and/or the judges of an internal court to determine the content, methods of exercise, and possible limits of the right to strike. The recommended approach is part of a broader approach designed to incorporate the concerns expressed by all the tripartite constituents. The responses from your court will provide guidance to the tripartite constituents by offering concrete avenues to ensure legal certainty and the proper functioning of the ILO supervisory system. Mr. President, ladies and gentlemen, members of the court, these remarks conclude my speech, and I thank you for your attention. I respectfully ask you to give the floor to Ambassador Valérie Bercé-Bircher, who will address the interpretation of Convention 87 and the question of jurisdiction to define the procedures for applying the right to strike. I will then present some concluding remarks. I thank Ambassador Frank Perez for his presentation. I now call upon Her Excellency, Ambassador Valérie Bercé-Bircher, to take the floor. Madam, you have the floor. Mr. President, members of the court, it is an honor and a privilege for me to appear before you on behalf of Switzerland. I shall deal with two aspects of the interpretation of Convention number 87, the object and purpose of the Convention, and subsequent practice. With regard to the object and purpose of the Convention, the title and preamble of Convention number 87 indicate that its object and purpose are to guarantee and protect freedom of association and the right to organize. Strike action is not the only means of defending workers' interests and protecting freedom of association. In fact, workers and their organizations have many ways of defending their interests, such as protests, media campaigns, petitions, electoral recommendations, as well as mediation and arbitration mechanisms. The importance and effectiveness of one or other of these methods varies considerably from one country to another. In this context, let me briefly mention the principle of industrial peace as it applies in Switzerland, which is probably unique to my country. The right to strike is expressly recognized in the Swiss Constitution and is subject to 4 conditions. The strike must relate to labor relations. It must comply with the obligation to maintain industrial
(3)(b) of the Vienna Convention on the Law of Treaties. Although fundamental, these requirements do not always seem to have been analysed in depth in the context of the present proceedings, and this may have led some participants to conclude wrongly that such a practice had been established. First of all, the conduct invoked must be attributable to the states parties to the treaties. In this respect, the practice of a supervisory body cannot on its own constitute a subsequent practice. Only conduct attributable to a state can qualify as such. The Committee of Experts alone cannot give rise to a subsequent practice unless the state's parties adopt this interpretation in applying Convention number 87. This brings me to my second point. For a subsequent practice to be relevant for the purposes of interpreting a treaty, it must establish the will of all of the state's parties. Declarations on the application of Convention number 87 vary considerably from one state to another. Switzerland and Japan, for example, had already stated in 1973 and 1965, respectively, that the right to strike was not covered by this convention. For more than 30 years, several states have clearly opposed the interpretation according to which Convention number 87 protects the right to strike. Nor can it be inferred from the statements and observations in these proceedings that there is a common subsequent practice. Some states have explicitly opposed the recognition of the protection of the right to strike by Convention number 87, and many others have not expressed an opinion. Thirdly, subsequent practice must establish the agreement of the parties with regard to the interpretation of the treaty. In this context, and despite the arguments sometimes put forward in the written procedure, ratification of a treaty does not establish the agreement of the parties to its interpretation. This is all the more true given that reservations are excluded in the ILO standards system, as I have recalled. Thus, even if ratification were to take place after the first observations of the Committee of Experts, subsequent ratification of Convention number 87, even by a large number of states, would not in itself constitute such a practice. When a state ratifies a treaty, it agrees to be bound by that treaty, and not by all the non-binding comments relating to it. Switzerland, for example, expressly stated when ratifying Convention number 87 that this convention did not cover the right to strike, despite the pre-existing recommendations of the Committee of Experts. Furthermore, the 2015 joint government statement to the ILO does not establish the existence of an agreement between governments on the interpretation of Convention number 87. They recognize the link between the right to strike and freedom of association. However, they specify that this right is not absolute and that the conditions for exercising it are regulated at national level. Without explicitly mentioning any link between the right to strike and this convention. Fourthly, in order to be recognized as such, subsequent practice must be followed in the application of the treaty. Although many states, including Switzerland, recognize the right to strike and attach particular importance to it, their practice in this area cannot be equated with subsequent practice in the application of Convention 87. The causal link between a state's protection of the right to strike in its national legislation and its recognition of the protection of that right by Convention 87 cannot be established. If it were to be accepted that conduct with no proven link to the application of a treaty without the explicit or tacit adherence to all the parties and with no clear connection to the convention concerned, this would constitute a subsequent practice and create profound legal uncertainty. In short, there is no sufficient evidence to conclude that there is a subsequent practice recognizing the protection of the right to strike under Convention number 87. Mr. President, members of the court, I would now like to turn to the question of competence to define the modalities of application of the right to strike. It is clear from the various written submissions that the arrangements for exercising the right to strike are defined at domestic level and fall within the competence of states. Many of them specify that these procedures are governed by their national legislation, regardless of whether or not they are recognized as being protected under Convention 87. The competence of national legislators to define the procedures for exercising the right to strike is also recognized in several international instruments and was reiterated by states in their joint declaration to the ILO in 2015. With regard to competence within the ILO, one question remains: do the supervisory bodies have the competence to define the modalities for exercising the right to strike? Or does this competence lie with other bodies, such as the International Labour Conference or an internal ILO tribunal? Before outlining the mandates of these various bodies, I would like to remind you that, in accordance with the ILO Constitution, only your court or any internal ILO tribunal is competent to interpret ILO conventions. As regards the supervision of matters relating to Convention number 87, or to the rights and principles of freedom of association and collective bargaining, two bodies may be consulted, namely the Committee of Experts and the Committee on Freedom of Association. The terms of reference of the Committee of Experts, defined in 1926 by the International Labour Conference, stipulate stipulated that its work would be technical and not judicial, and that the monitoring of the application of standards should be separated from the interpretation of their content. Since 2014, the Committee of Experts has emphasized in each annual report that its mandate consists of a technical and impartial analysis of the implementation of ratified conventions. In doing so, it examines the legal scope, content, and meaning of the Convention's provisions. Its opinions and recommendations are of a non-binding nature, their purpose being to guide the action of national authorities. Although the Committee of Experts may issue opinions on the scope and meaning of standards when examining their implementation, it is not within its remit to interpret them. The second supervisory body is the Committee on Freedom of Association. Its mandate is to determine whether, in concrete terms, national legislation or practices comply with the principles of freedom of association and collective bargaining. This is a tripartite body on which I represented governments for a number of years. This body examines specific allegations of non-compliance with the principle of freedom of association, regardless of whether or not the state against which the allegations are made has ratified one of the conventions relating to the fundamental principle. The recommendations of the Committee on Freedom of Association have the value of invitations or proposals to governments to adopt measures. Thus, as with the Committee of Experts, the Committee on Freedom of Association is not empowered to interpret ILO conventions. The ILO Constitution entrusts the International Labour Conference with the task of drawing up international standards within a tripartite framework. Although the conference does not have the power to interpret an existing standard, it can nevertheless amend it or adopt new standards, or even a protocol to a convention. The conference could therefore, if the ILO's constituents so wished, adopt a new standard defining the modalities of the right to strike. This would be technically and legally possible. Finally, the creation of an internal ILO tribunal, as provided for in Article 37, paragraph 2 of the Constitution, would provide a rapid tripartite mechanism guaranteeing the inclusion of all constituents and legal certainty for settling any differences of interpretation that might arise. In short, if it were to be accepted, the Convention 87 protects the right to strike. It would be appropriate to define which of these four bodies would be competent to determine the modalities of the right to strike. Mr. President, members of the Court, thank you for your attention. I would respectfully ask you to give the floor to Ambassador Perez, who will briefly conclude Switzerland's intervention. I thank Ambassador Valérie Bercé-Bischoff for her presentation. I now call upon His Excellency Ambassador Perez. Sir, you have the floor. Mr. President, members of the Court, on behalf of Switzerland, I would like, first of all, to express our gratitude for the attention given to these proceedings and stress how essential it is for the Court to clarify a complex and sensitive situation. The lack of clarification has led to prolonged tension and uncertainty that is detrimental both to the member states and to the other constituents and to the ILO itself. In this respect, it is worth recalling the specific nature of the ILO's tripartite model, which is based on the constant search for a balance and on reaching a consensus between governments, employers, and workers. It was not possible to reach such a consensus on the question of the right to strike under Convention number 87, either when the Convention was adopted or during its implementation. It is also important to bear in mind the constitutional provisions and procedures that govern the proper functioning of the ILO. For example, the ILO Constitution gives the International Labour Conference, as a legislative body, the possibility, if its constituents deem it appropriate, to adopt, on the basis of a tripartite consensus, a new standard specifying the conditions for exercising the right to strike. The Constitution also envisages the establishment of an internal tribunal which could be responsible for ruling on differences of interpretation. Such a solution, respectful of the institutional framework of the ILO, would ensure inclusiveness, balance, and legitimacy. Mr. President, members of the Court, to summarize, the question put is not whether the right to strike exists. All parties to the proceedings recognize the existence of such a right. The question which is put to you is whether Convention number 87 covers this right. With regard to the interpretation of Convention number 87, it emerges from the rules of interpretation of international law that this convention does not protect the right to strike. If your court, however, were to consider that the right to strike is protected by Convention number 87, it would be essential to provide additional guidance to the tripartite constituents. There are, in fact, as many ways of applying the right to strike as there are states. It is therefore essential for the court to determine which body or authority is competent to define the procedures for exercising this right. This would provide greater predictability and consistency in the application of this rule. Mr. President, members of the court, in a context of growing mistrust of multilateralism, it is all the more crucial to restore confidence among stakeholders and to ensure that the ILO remains a reliable, predictable, and respected framework for the regulation of labour relations at the international level. Legal certainty and institutional stability must remain at the heart of our priorities. They are the very foundations of the commitment of states and the durability of the multilateral system. Thank you for your attention. I thank the representatives of Switzerland for their presentation.
We'll observe a coffee break of 50 minutes. The hearing is suspended.
Mr. President, members of the court, it is a privilege to address you today. I will focus on why the right to strike is indispensable from a practical and principled standpoint, in particular for ensuring a just transition in the face of climate change, for achieving sustainable development, and for protecting the rights of workers, including migrant workers, through labor mobility. These contexts illustrate the real-world stakes of the legal question before you. First, on the just transition, at the international community increasingly recognizes a just transition of the workforce is imperative as we shift to environmentally sustainable economies. The Paris Agreement, ratified by nearly all ILO member states, explicitly acknowledges the imperative of a just transition of the workforce and the creation of decent work and quality jobs in its preamble. This concept, born from trade union advocacy decades ago, reflects the understanding that climate action and labor rights must progress hand in hand. In practice, a just transition means that when the right to strike is not only about resolving labor disputes over wages or conditions. It is fundamentally about enabling workers to participate in shaping their economic and social destinies. Decent work for all is key goal of the 2030 Agenda for Sustainable Development, SDG 8. In practice, decent work requires that workers have a genuine voice, the ability to collectively negotiate, and when necessary, withdraw their labor. Societies that uphold the right to strike tend to have a more robust social dialogue mechanisms, which in turn lead to more stable and inclusive economies. Conversely, denying workers lawful strike rights often correlate with deeper social inequalities and unrest. Hence, our alignment with the strong consensus that the right to strike is a fundamental component of freedom of association. Third, labor mobility, a matter of special importance to Vanuatu and many other small states. As the Attorney General noted, a significant portion of our population works abroad in seasonal or temporary employment. For these workers, the right to strike can be a matter of basic dignity and safety. Far from home, often in low-skilled jobs, migrant workers are especially vulnerable to exploitation. They may face long hours, substandard housing, or breaches of contract. In such situation, the ability to organize and collectively protest, including through strikes or work stoppages, can be their only effective recourse to prompt improvement of conditions. I wish to emphasize that when Vanuatu sends its sons and daughters overseas to work, we entrust their well-being partly to the framework of international labor standards. We rely on the promise that all states that benefit from their labor will respect fundamental rights. Among these, the right to strike is a litmus state test of a state's commitment to treating workers fairly. If our citizens abroad are legally barred or practically prevented from ever striking, this is a signal that something is amiss in the balance of power. Conversely, in environments where strikes are absolutely forbidden, we have seen grievances fester and moral deteriorate, undermining productivity and development outcomes. Importantly, labor mobility has also impact at home. While it brings income, it can lead to skill shortages and social strains when so many workers are abroad. A well-managed labor mobility scheme thus requires input from workers' organizations to ensure it remains sustainable. For instance, through policies for integration or skills transfer. Here again, the right to strike underpins the strength of those workers' organizations. It gives union leverage to negotiate better terms for participants and to hold governments accountable in managing these programs. Mr. President, distinguished judges, the example I have given share a common theme. In each context, climate transition, sustainable development, and labor mobility
underpinning that interpretation. In essence, we submit that by applying the customary rules of treaty interpretation as reflected in Articles 31 and 32 that of the CLT, one reaches the clear conclusion that the right to strike is protected under Convention 87. The conclusion is reinforced by subsequent practice, the jurisprudence of international supervisory bodies, and the broader corpus of international law, including human rights law. I will address these points in turn and then conclude with Vanuatu's respective requests to the court. First, context and purpose of Convention 87. Interpreted in good faith in accordance with the alternative meaning of its term in the context and in light of its object and purpose, Convention 87 encompasses the right to strike. Several provisions of the convention, read together, lead inexorably to this point. Article 3 guarantees that workers and employers organizations may organize their activities and formulate their programs freely. Article 10 defines such organization as the furthering and defending workers of employers' interests. By their ordinary meaning, these provisions cover collective industrial action. Excluding strike because the word is not explicit would hollow out freedom of association. The convention purpose to secure social justice through freedom of association confirms that strike protection is an indispensable corollary of the freedoms guaranteed. Second, subsequent practice and authoritative interpretations. The practice of states and the assessment of competent international parties over the decades overwhelmingly support the view that Convention 87 protects the right to strike. The ILO's supervisory mechanism have consistently and ambiguously interpreted Convention 87 this way for nearly half a century. State parties have been well aware of this interpretation. Significantly, not a single state moved to denounce or amend Convention 87 in protest of this interpretation. On the contrary, dozens of states chose to ratify Convention 87 in the years after the right to strike interpretation was firmly established. Vanuatu itself ratified Convention 87 in 2006 at a time when the understanding that it protected the right to strike was already long-standing and widely accepted. By ratifying Vanuatu, like many others, endorsed that prevailing interpretation. This constitutes powerful subsequent practice indicating agreement on the treaty's meaning. That wider international legal landscape and its interpretative relevance. Article 31(3)(c of VCLT instructs the interpreter to take into account any relevant rules of international law applicable in the relations between the parties. The relevant rules landscape comprises three interlocking elements. First, customary international law and general principles of law, which apply by the nature to all states and therefore by definition and applicable in the relations between the parties. The long-standing characterization across ILO protective and comprehensive jurisprudence of strike action as an intrinsic element of trade union, freedom forms part of that background. Second, other treaty commitments binding on many parties to Convention 87, including International Convention on Economic, Social, and Cultural Rights, which expressly protects the right to strike, and contains a saving clause that presupposes at least equal protection under Convention number 87. The International Covenant on Civil and Political Rights, whose Article 22 protects freedom of association and cross-references ILO guarantees, and regional instruments which courts and organs have read freedom of association to encompass strike action. Third, the Charter of the United Nations and the ILO Constitution, which commits states to protect universal respect of human rights and fundamental freedoms, fundamental principles and rights at work. Commitments that inform rather than amend the understanding of the scope of Convention 87. An objection has been raised that Article 31(3)(c) sets a demanding threshold, and that because not every party to Convention number 87 is also a party to the ICESRCR, in particular including Vanuatu. The covenant cannot be used in interpreting the convention. With respect, that objection conflates two distinct points and overstates the threshold in both. First, Vanuatu's conclusion does not depend on importing right to strike from external treaties. It follows from Convention 87 itself, its ordinary meaning read in context and in light of its object and purpose before one ever looks beyond the instrument. In this sense, the wider legal landscape is confirmatory, not constitutive. Second, systemic integration does not require that every single state party to Convention 87 be bound to every other rule considered. Customary norms and general principles are by their nature applicable to all. And when interpreter considers other treaties, those rules are not being used to amend Convention number 87, but to confirm the reading that best fits its terms and purpose, and to evidence a widespread across regional understanding of the right at issue. The absence of a regional instrument in one geographical area does not detract from this cross-regional convergence, nor from the Charter based on commitments that all UN members share to promote universal respect for fundamental rights. Fourth, travel preparatoire. Article 32 of the CLT permits recourse to preparatory work only if the primary interpretation leaves the meaning ambiguous or leads to an absurd result, which is not the case here. Nonetheless, even the travel preparatoire of Convention 87, when carefully examined, do not negate the right to strike. Contemporary records indicate that the drafters were aware of the right to strike issue and largely assumed it as implicit in freedom of association. This is corroborated by the approach taken in subsequent ILO instruments, such as Convention 98 on collective bargaining, and by statements from many participants in these proceedings. Mr. President, distinguished members of the court, in whole, crumbling with overlooking challenges of economic inequality, climate change, migration and technological disruption, meaningful social dialogue and cooperation are indispensable. Upholding the right to strike globally will strengthen the hand of those striving to ensure that transitions are carried out with fairness and respect for human dignity. It will also reinvigorate the ILO's century-old promise to workers that their rights are upheld in the quest for social justice, consistent with the 2030 Agenda and the Paris Agreement. It's called to consider the needs of the workforce. Failing to acknowledge the right to strike would undermine the normative framework of international cooperation on just transition and sustainable development goals. By contrast, a clear affirmation by this call court will safeguard a key element of that framework. For all the reasons we have outlined, the Republic of Vanuatu respectfully requests the court to declare that the right to strike of workers, their organizations, is protected under Convention number 87. Such an advisory opinion will not only reflect the correct legal interpretation of Convention 87, but will also strengthen the foundations of a just transition, sustainable development, and human dignity that are at the heart to the ILO's mandate and the United Nations Charter. Thank you, Mr. President and members of the court for your attention. This concludes Vanuatu's oral submissions.
I thank the representatives of Vanuatu for their presentation. I now give the floor to the delegation of the International Cooperative Alliance, and I invite Mr. Santosh Kumar Panmanaramahan to the podium. So you have the floor.
Mr. President, distinguished members of the court, it's my greatest honor to appear before you in the matter concerning the right to strike under ILO Convention 87. From their earliest days, formally and informally organized cooperatives through their national and eventually international structures have stood at the forefront of movements advancing social justice for their members and their communities. They have been and remain steadfast participants in the pursuit of equity, dignity, and shared prosperity. Even today, they continue to be deeply invested in and profoundly affected by the challenges and aspirations of their members and communities, whether at the local and national levels or beyond. Recognizing this enduring commitment, the United Nations General Assembly has proclaimed the year 2025 as the International Year of Cooperatives, after first proclaiming it in the year 2012. In doing so, the international community has acknowledged the economic, social, and cultural value and contribution of cooperatives to humanity's collective well-being. It is fitting, too, that this same period is being marked as both the International Year of Glaciers Preservation and the International Year of Peace and Trust, themes that remind us of our shared responsibility towards the planet and towards one another. It is within this broader context that I have the distinct privilege of representing before this court the International Cooperative Alliance, an institution that since 1895 has striven to safeguard the cooperative identity and practices of nearly 1 billion cooperators worldwide today, who are engaged as producers, workers, or users, and essential stakeholders of approximately 3 million cooperative enterprises worldwide.
Zanzibar, Uruguay, and Vietnam. It is recognized by all the existing regional uniform laws on cooperatives that is the 2003 European Council regulation on the Statute for a European Cooperative Society, the 2010 Acte uniforme relatif aux sociétés coopératives de l'Organisation pour l'harmonisation en Afrique du droit des affaires, and the 2014 East African Community Cooperative Societies Bill. It is recognized by regional model laws on cooperatives, that is the 2008 Framework Law for Cooperatives in Latin America, and the 2024 African Union Model Law on Cooperatives for Africa. It is recognized by legally relevant international instruments, such as the ILO Promotion of Cooperatives Recommendation, number 193, the 2001 United Nations Draft Guidelines aimed at creating a supportive environment for the development of cooperatives, and the 2021, 23, and 25 biannual reports of the Secretary General of the United Nations on Cooperatives in Social Development. And it is also recognized by public international law. Article 12, Section 2 of the Articles of Association of the ICA, in connection with Article 22 of the International Covenant on Civil and Political Rights, and the legal principle of the prohibition of contradictory behavior by states, leads to conclude that legislators have a legal obligation to translate the cooperative identity into law. By providing a legal framework that is in line with the identity of cooperatives, and by providing the legal justification for the claim to have cooperative adequate legislation, these laws and texts concretize the legal principle of equal treatment recognized as a source of law by all national laws and by Article 38 of the Statute of this Court. Under Article 10, Section 2b of the Constitution of the ILO, the International Labour Office, and I quote, shall accord to governments at their request all appropriate assistance within its power in connection with the framing of laws and regulations on the basis of the decisions of the conference and the improvement of administrative practices and systems of inspection, unquote. Among those decisions of the conference is the ILO Recommendation 193. This recommendation specifies in its paragraph 10, Section 1, how governments should frame laws and regulations on the basis of Recommendation 193, namely by adopting, and I quote, specific legislation and regulations on cooperatives which are guided by the cooperative values and principles set out in paragraph 3, and revise such legislation and regulations when appropriate, unquote. With modifications that are not relevant here, paragraph 3 of the ILO Recommendation 193 contains the values and principles enshrined in the ICA statement. As paragraph 2 of the ILO Recommendation 193 defines cooperatives in exactly the same words as does the ICA statement, it is clear that such legislation and regulations must ensure that cooperatives also meet the social aspect of the needs of their members. The capacity of the International Labour Office to assist governments in this task is to a large extent determined by the information and knowledge provided to it through the reporting mechanisms of Article 19 of the Constitution of the ILO in respect of conventions and recommendations, as well as through the work of the Committee of Experts on the application of ILO conventions and recommendations. Limiting the mandate of the Committee of Experts on the application of ILO conventions and recommendations to scrutinizing the implementation of these instruments without interpreting them, as suggested by some of those actors who opine that the right to strike is not protected by ILO Convention 87, constitutes an impossibility. Interpreting is inherent in scrutinizing the implementation. Furthermore, such limitation of the scope of the scrutiny would then also have to apply to the scope of the obligations to report under Article 19 of the Constitution of the ILO. Both these limitations would create a precedent for other ILO instruments, the ILO Recommendation 193 included. The capacity of the International Labour Office to assist governments to having a cooperative identity adequate legislation according to paragraph 10, section 1 of the ILO Recommendation 193 would be reduced. This in turn would risk affecting the capacity of cooperatives to cater for social justice in two respects, and it would void the sense of the right to associate. As concerns social justice, the reason is the following. To the extent the right to strike diminishes the capacity of workers to cater for social justice, the burden of cooperatives to do so increases. At the same time, the capacity of cooperatives to bear this increased burden is put at risk by weakening the International Labour Office's capacity to influence governments to have cooperative law in line with ILO Recommendation 1 and 3. That is, law that ensures that cooperatives meet also the social needs of their members through the specific form of their enterprise as concerns its financing, governing, auditing, etc. While all enterprise types are increasingly subject to social and societal obligations, and while the number of laws on the promotion of social and/or solidarity economy actors is rising, cooperatives remain so far the only enterprise type that by its objective and consequently by its form has to address social justice concerns of its members and, according to one of the cooperative principles, those of the wider community in which they are active. In times when the prospects of maintaining or creating effective welfare state systems are diminishing, this capacity of cooperatives must be maintained and promoted. As concerns the right to associate, protected under Article 22 of the International Covenant on Civil and Political Rights, it must include the right to choose the objective to be pursued through the association and the right of those associated to employ any peaceful means they think best to pursue the objective for which they came together, independently of whether this means is effective, and all the more when it has proven effective, like the exercise of the right to strike has in countless circumstances in terms of social justice. Again, a negative answer to the question whether ILO Convention number 87 protects the right to strike would affect this right of cooperatives and their members, as the mentioned diminished power of the International Labour Office to influence cooperative lawmaking would heighten the risk of maintaining existing restrictions concerning activities of cooperatives, such as, for example, the prohibition of being active in the financial sector that many countries have, as well as heighten the risk of continued companization of cooperatives through law, that is, the approximation of their features with those of capital-centered enterprises, and by applying to them laws that do not take the cooperative identity into account, such as accounting standards, labor laws, etc. Finally, aware of the Court's recent advisory opinion on the climate change obligations of states of July 23, 2025, which deepens the notion of sustainable development, and in addition to what the ICA invoked already in its written contribution concerning the link between social justice and sustainable development, the ICA would like to draw the Court's attention to the link between the capacity of cooperatives to cater for social justice and Articles 55 and 56 of the Charter of the United Nations Organization, as well as the International Covenant on Economic, Social and Cultural Rights. This covenant is a necessary complement to the International Covenant on Civil and Political Rights, and it addresses economic, social and cultural rights, as does the mentioned definition of cooperatives. To conclude, the ICA expresses again its gratitude for having the opportunity to be part of this procedure, and I myself thank you, Mr. President, and the esteemed members of the Court for your attention. Thank you.
I thank the representatives of the International Cooperative Alliance for their presentation. I now invite the delegation of Business Africa to address the court, and I call Mr. Kaiser Muyan to the podium. Sir, you have the floor.
Mr. President, Madam Vice President, members of the court, it is an honor and a great responsibility to appear before you on behalf of Business Africa. I sincerely thank the court for organizing these proceedings on the ILO's request for an advisory opinion. I also extend Business Africa's appreciation to all the participants in this process. Business Africa seeks to influence policy by enhancing the African business voice in international, continental, and regional bodies such as the International Labour Organization, the United Nations Economic and Social Council, the African Union Commission, the African Development Bank, the European Union, the regional economic communities in Africa, and other continental bodies. We work for the promotion of industrial peace in all enterprises in Africa by the development of sound industrial relations and personnel management practices. We do so by advocating for a conducive business environment that facilitates sustainable enterprises and employment for socio-economic development in Africa through our network of national employers and business organizations. This role provides a vital perspective on the question before the court, because our mandate affords insight into the circumstances and needs of employers, workers, and governments. And it does so in a continent facing a position of relative economic disadvantage in comparison with many of the non-African states which have made submissions to you and the membership of the ILO more broadly. It would be quite wrong to ignore the fact that it is upon commercial activity that the livelihoods and prospects of workers and the economic development of nations depends. Businesses in Africa are among the most exposed to the risks that a reduction in commercial activity entails. Calls by some, mostly Western industrialized economies, to impose a homogeneous model on the right to strike will shrink the policy space available to developing economies. Earlier industrializers benefited from having choice over policy space, and with it, choice about how to sequence labor institutions with local economic needs. Historically, now rich countries built industrial capacity under protective policies and only later codified the full range of complex social protections that now exist in those countries. The imposition of a single model in respect of the right to strike would invert that sequence. It is difficult not to see it as the result of an effort by more economically powerful countries to pull up the drawbridge once they had attained economic prosperity. It would undermine the ability of developing economies to tailor strike laws in a manner that serves their most pressing economic need, the struggle to lift hundreds of millions of people out of poverty. This is as important a goal, and one that weighs on the social conscience of those of us living in and working in relatively economically disadvantaged regions. How this can be done is best determined by governments, employers, and workers, not international judges, and certainly not by retrofitting a boilerplate into an historic instrument that was never intended for it. I cannot emphasize strongly enough the importance to commerce in Africa of the ILO's unique structure, which brings together on an equal footing employer, worker, and government representatives from all of its 187 member states. Tripartism is one of the ILO's 4 fundamental principles, and it is the linchpin to ensuring interaction and cooperation so as to arrive at decisions which respect the equal status of workers, employers, and governments. The tripartite nature of the organization has been widely considered to provide the ILO with a unique advantage and to provide its actions, and in particular the international labor standards that it sets and supervises, with legitimacy. It is only through the standard-setting procedures that there is a guarantee, as envisaged by the ILO Constitution, that all ILO constituents can participate in the design of these rules. Moreover, it is only through the application of the ILO's proper standard-setting procedures that any codification of the right to strike will be able to take into account the diverse industrial relations systems and specificities of all member states. Mr. President, members of the court, Business Africa reaffirms its unwavering commitment to the rule of international law, which must finally prevail. I will be followed today by Mr. Paul Clark on behalf of Business Africa, who will address the nature of the question before the court and the principles of treaty interpretation. I thank you for the honor of addressing you. And now I request, Mr. President, that the court calls on Mr. Clark. Thank you.
I thank Mr. Muyan for his presentation. I now call upon Mr. Paul Clark to take the floor.
Mr. President, Madam Vice President, distinguished members of the court, it is truly an honor to be here to appear before you. And although it is said frequently, I mean it wholeheartedly when I say that it is a privilege to advance the arguments of Business Africa on a question which is of such significance for socio-economic development in Africa. I hope that you will forgive me for beginning the way that so many have, with the terms of the request for an advisory opinion. It requires the court to determine whether or not the right to strike is protected by Convention 87. I will spend the larger part of my time on the nature of the question before you, because it's only on that basis that the task of treaty interpretation under the Vienna Convention can be approached with real precision. Having done so, I'll be in a position to address the question of interpretation briefly, not least as I have the benefit of having heard the cogent submissions on behalf of the IOE, which Business Africa adopts. The decision for the court to make as to whether Convention 87 protects the right to strike does not raise the question of whether workers should be excluded from strike action. Their ability to do so and the regulation of it is rooted elsewhere, in domestic law, in some regional human rights conventions, and otherwise. There is nothing to exclude their ability to use strike action in the eventuality that Convention 87 does not protect the right to strike. The ITUC wrongly implied the contrary throughout their submissions, such as when it was argued on Monday that, and I quote, "There is no reason to exclude strikes from what workers can do to protect themselves." Business Africa agrees entirely with that statement on its own terms, but it is simply of no consequence to the matter before you. Somalia wrongly said, and I quote, "These proceedings concern the existence of a right to strike." The exclusion of strike action is not at stake in these advisory opinion proceedings. Indeed, you've heard many references to sources of a right to strike action which exist regardless of the content of Convention 87. That being so, the proposition that Convention 87 protects the right to strike requires that Convention 87 has something to say about the parameters of strike action. and not the possibility of whether the possibility of strike action should be excluded. Indeed, those, including Business Africa, who argue that the question before the court must be answered negatively, expressly recognise that workers do have a right to strike. Interpreting the question requires clarity about its object. What is a right to strike? What is the thing to which the question relates? No one suggests it's absolute. That is a point that's been made repeatedly. It is a qualified right wherever it exists, and so it brings with it nuance and calibration. Unlike freedom of association in general, and unlike many of the other steps that workers may take in seeking to advance and protect their interests, a strike is a relatively extreme measure, often viewed only as a matter of last resort. Its exercise necessarily has economic and social consequences which impact upon the rights and interests of others. This only serves to emphasize the inherent need for limitation. So, from where does the calibration come? 4 possibilities emerge from the submissions that you've heard. I will suggest that 1 is a red herring and that there are only 3, of which none are compatible with the proposition that Convention 87 protects the right to strike. I should emphasize at the outset that none of these options involve suggesting that it should be this court which provides the requisite calibration. As I will contend, it is absolutely imperative that if Convention 87 were to be considered to contain a right to strike, which Business Africa maintained it does not, but if it does, the means of calibration must emerge through the ILO's tripartite principle. The first source of calibration is what might be called the legal elsewhere. It's not Convention 87. It's those aspects of domestic law and regional or international law which do speak to the possibility of strike action or to the right to strike. This means that Convention 87 simply does not get involved in the protection or the regulation and calibration of the right to strike, because that is being done elsewhere in the legal landscape. The second possibility, to which the ITUC referred in their submissions before you on Monday, is the content of Convention 87 itself. In submissions on Monday, on behalf of the IUT in this regard, reference was made, in particular, to limits being imposed by, and this is a quote, the law of the land in Article 8, subparagraph 1, the reference to lawful in Article 3, subparagraph 2, and Article 9, which, as the ITUC noted, allows states to exclude the police and the armed forces from the scope of the Convention's application. Even if the text of Convention 87 relates to activities other than internal ordering, the reference to the law of the land, if applied to the possibility of strike action, says simply that a calibrated right to strike is to be found in domestic law. The reference to lawful in Article 3, subparagraph 2, adds nothing to the law of the land, other than, perhaps, to acknowledge the possibility that a state's domestic law incorporates the content of regional human rights conventions. The only real indication of a limit is the possibility of excluding the police and the armed forces. But Article 9, subparagraph 1 simply refers to domestic law in this regard, when it says, shall be determined by national laws or regulations. In any event, mere reference to the specificity of the armed forces and the police is plainly insufficient calibration, not least as it says nothing about the limits and modalities of strike action by anyone other than the police and the armed forces. There is no real limitation or qualification to a purported right to strike in Convention 87. it is a red herring. The third possibility is the views of the Committee of Experts and the CFA. But this is a unilaterally devised conglomerate of rules on scope, conditions and limits of workers' resort to strike action. In so doing, the Committee of Experts has acted outside of its competence and mandate. And here, I emphasise strongly the distinction between ex-ante standard setting and ex-post supervision. To allow the views of the Committee of Experts to determine the content of an ILO convention would stand in the starkest of contrast to the proper tripartite process under the constitution of the ILO. Our submission, and that of the employers and some governments, is that in doing so, the Committee of Experts has acted outside its competence and its mandate. But even leaving that aside, it is self-evident that the comments and observations of the Committee of Experts are not arrived at through the constitutionally enshrined procedure for standard setting. To accept its comments and observations as determinative of the content of the treaty would subvert tripartism, causing further instability within the carefully calibrated ILO system. I will return to the relevance of this when I turn to the task of treaty interpretation. The fourth possible source of calibration is that of a distinct ILO instrument on the right to strike. Such a convention, crucially, would be arrived at through tripartism and the processes mandated by the constitution of the ILO. Through its tripartite International Labour Conference, the ILO could have adopted a convention on the right to strike, which would necessarily include the question of its scope, its limits and its conditions, and which provides a proper, constitutionally sound basis for supervision of a right to strike. And it still could do so without further delay. It's worth noting that this is what the employers group, as well as many governments, have repeatedly attempted to put on the agenda of the International Labour Organization. Even though the government group of the ILO governing body indicated its readiness to discuss the existence of a right to strike back in 2015, such substantive discussion has simply not taken place at the governing body or at the International Labour Conference to date, due to the refusals by the workers' group to participate in such a process. I've sought to persuade you of two things so far. First, that the requirement of calibration inheres in the very concept of a right to strike and in any effort to protect it. And among the possible sources of such calibration, serious and significant problems arise if the source of calibration of a right to strike emanating from Convention 87 is in the views of the Committee of Experts or the CFA. I hope that clarity as to the meaning of the question of whether Convention 87 protects the right to strike will allow real precision in the application of the principles of treaty interpretation. The ITUC and others argue that the bare text of Convention 87 includes the right to strike because it is included in the word activities. I've tried to show why a choice to include striking, as only one example among many, brings with it a need for calibration and specification, and that Convention 87 is an inappropriate vehicle for that. The absence of treatment in the text of the inherent need for calibration underscores that point further. As to context, its role in interpretation is by reference not only to the structure of Convention 87, but also to any agreement made between the parties in connection with the treaty's conclusion, or any instrument made by one or more parties in connection with the treaty's conclusion and accepted by the other parties as such. As the workers' group themselves acknowledged, the references to freedom to organise in Convention 87 must be understood in the context of the relevant provisions of the preamble, the ILO Constitution, and of the Declaration of Philadelphia. The proper process of standard setting is constitutionally entrenched in the ILO. A finding that Convention 87 and contains that which the Committee of Experts considers to be the right to strike would give the imprimatur of this Honourable Court, ex post facto, to a form of unsanctioned, illegitimate unilateralism. As to the argument asserting a purported need for consistency with human rights law, it would be absurd to deny that certain international and regional instruments explicitly or implicitly refer to a right to strike. However, across these examples, the right has a very different scope, set of conditions and limits. The application of human rights law is able to refer to a right to strike without it collapsing under the weight of variation and national specificity, because of the application of subsidiarity and the invocation of a broad margin of appreciation when it refers to the right to strike. This institutional context in which the ILO applies Convention 87 is entirely different and lacks these features. But it is the question of object and purpose which is the beating heart of the argument advanced by those who contend that Convention 87 does include a right to strike. The ITUC made the argument on Monday that strike action should be included in Convention 87 in order to facilitate the effectiveness of trade unions. But it was perhaps in asserting that Convention 87 does not protect the right to strike, but it was perhaps in the assertion that a ruling that Convention 87 does not protect the right to strike, and I quote, could be used to destabilize industrial relations and deny the very existence of workers' rights in countries hostile to those rights, that this teleological line of argument reveals its true colours. This, like the other less extreme teleological arguments that you've heard over the last 2.5 days, of course, is contingent upon a particular interpretation of the question before the court. Whether to exclude strike action from the measures available to workers, or whether a right to strike exists at all. This interpretation is simply wrong. The extreme language of the ITUC was misplaced and misconceived. The ITUC effectively asks you to somehow take action to prevent what would already be internationally unlawful acts, and in so doing makes a mistake, mistakes a question of interpretation for a question of enforcement. It is straightforwardly a category error, a disorientated teleology. I've neither the time nor the need to address the remaining issues under the Vienna Convention. The UK convincingly dismantled the proposition that customary international law militates in favour of a finding that Convention 87 protects the right to strike. The IOE and Switzerland have shown convincingly the absence of subsequent agreement or subsequent practice for the purposes of Article 31(3). The repeated characterisation of Business Africa's position as that of a minority view seeks to distract from the principles of treaty interpretation, which are certainly not driven by majoritarianism. I note in passing that this characterisation is also wrong on the facts. Many governments support the view that the right to strike is not protected by Convention 87, and many governments which form part of the ILO do not explicitly support the workers' views. Indeed, during the governing body's discussion to submit this question to the court, around half of the room supported the approach of the employers. Professor Klein for the ITUC sought to persuade you that the right to strike is the right to strike, regardless of its origins, by using a metaphor. As being wet is a corollary of being immersed in water, you'll be wet in any event. It doesn't matter whether you swim in the Scheveningen Sea or relax in your bathtub. So, by analogy, you were encouraged to interpret the right to strike into Convention 87, since such a right is linked to free association elsewhere. But, Mr. President, I say that the source of your soaking does matter. Yes, in both the bath and in the sea, one will get wet. But it's only in the sea, with its riptides and currents, that there is a real chance of drowning. And so it is within the international labour system, and in particular, the question of the right to strike. The source of a legal right can be of great significance. That is why we say that here, the right to strike needs to be accompanied by appropriate limits and clear modalities determined, and I emphasise this, by the ILO's tripartite process. This is necessary in order to uphold workers' rights and to ensure the protection of the public at large with respect to minimum service requirements for essential services. The importance of the source of the legal right in this context goes beyond even these critical matters. To grant the imprimatur of this honourable court ex post facto to the unsanctioned, illegitimate unilateralism of the Committee of Experts' views as to the right to strike would destabilise the unique balance of the ILO's tripartite system. As Panama rightly observed in their submissions to you yesterday, if we rewrite the convention in this way, then every contentious topic would become susceptible to recodification, thus eroding the rule of law in the ILO. Tripartism is also the means by which the equality of workers, employers, and governments is maintained and respected in the ILO system. There's an unfortunate irony in the fact that the workers' own efforts to win a long-running dispute in the ILO would undermine the very structures which give them, as well as the employers, agency in the ILO's lawmaking and standard-setting processes. The real wider implications of the question before the court does not involve excluding workers from strike action or diminishing the effectiveness of trades unions, or even encouraging abuse of their human rights through the media or otherwise. What is really at stake is upholding the propriety of the ILO's tripartite processes pursuant to the ILO Constitution. Not only does proper process through tripartism underpin the rule of law within the ILO, it is a rare example of practice which encourages what Professor Balakrishnan Rajagopal calls international law from below, giving voice to those who've historically been silenced within the institutions of international law. It affords agency in decision-making to those who are directly involved in the commercial activity upon which the livelihoods and prospects of workers and the economic development of nations depends. In line with Mr. Moyane's comments at the outset, this makes the tripartite processes vital to socio-economic development in Africa. Mr. President, Madam Vice President, distinguished members of the court, I thank you for the honour of addressing you and for your patient attention.
I thank the representatives of Business Africa for their presentation. This presentation concludes the oral statements by all of the participants who have expressed a wish to take part in the present oral proceedings. I note that the hearings are now closed on the request for an advisory opinion submitted to the court by the governing body of the International Labour Organization on the question of the right to strike under ILO Convention number 87. I'd like to convey the court's thanks to all the delegations who have addressed the bench over these last 3 days, as well as to the participants in the written proceedings. I would also ask the representatives of all participants to remain at the disposal of the court in case it should require any further information or explanations from them. The court will now retire for deliberation. The registrar will in due course inform the Director General of the International Labour Organization and all of the participants in these advisory proceedings of the date and time when the court is to render its opinion. As the court has no other business before it today, I declare this sitting closed.